let me begin with this slide in which I have left we ended with the last class. Now, we were talking about the place of suing. Now, to be very precise, a suit, patent infringement suit can be filed where the defendant resides, carries on business or works for gain. It can also be filed where the cause of action has fully or in part has arisen. To give you an example, suppose the patented article, the infringed article is being produced in Kolkata and the infringed article is being sold in Mumbai. In that case, the patent holder has the choice. He can file the patent infringement suit in Kolkata. He can also file the patent infringement suit in Bombay. Suppose the infringer stays in Bombay, the person who is making the infringing article stays in Kolkata, the person who is selling the infringement article stays in Bombay. In that case also, the defendant, there are multiple defendants. The first infringer is the person who is manufacturing the infringing article. The second defendant is the defendant who is selling the article. Both of them are infringing the rights of the patent holder under section 48, and therefore, again the suit can be filed in Kolkata, it can also be filed in Mumbai. Now, let me begin how such becomes important here, and for that actually we need to understand what is revocation. We have seen that the very idea of patent is to ensure that it does not shrink the public domain, and there are checks and balances throughout the life of the patent. The first challenge comes before the grant, and we know that is actually called the objection under 25(1) of the Patent Act, which is called pre-grant opposition. Thereafter, after the grant of patent, there is a 1 year window period. Within that, still it is possible for any member of the public to object to the patent, and this is called what you call the post grant opposition, and which has been embodied, which has been enumerated in section 25(2) of the Patent Act. Now, in addition to that, throughout the life of the patent, it is always open for any member of the public to challenge the validity of the patent, and which is known as revocation of patent, and which has been embodied in section 64 of the Patent Act. Now, who can actually, if you look into section 64 of the Patent Act, you will find that in fact 3 categories of litigants can challenge it. Number 1, any person who is interested, that means any member of the public can file a start a revocation proceeding seeking revocation of the patent. The central government can do it, and as we have understood from the previous class that it is also possible for a person against whom a patent infringement suit has been filed to claim a revocation in the form of a counter claim. Now, who are the authorities, who are the which are the tribunals and which are the courts who can do it? Normally, when a standalone revocation proceeding has been started, as per the provision of section 64, it has to be initiated before the Intellectual Property Appellate Board, and which is situated in the city of Chennai. However, whenever a revocation is claimed in the form of a counter claim in a suit, even if the prior revocation proceeding is pending before the Intellectual Property Board, all papers, because the moment the patent holder has filed a patent infringement suit against the person who has initiated revocation proceeding before IPAB, IPAB has to transfer all document to the relevant high court where the patent infringement suit is being tried. And in that case, the high court would not only be looking into the issue of infringement, but the high court would also be looking into the issues of revocation. To be very precise, revocation is nothing but a de novo assessment of the validity of the patent, de novo assessment of all the criteria of patentability. And therefore, the revocation is basically also a de novo search. It might happen that you may not be a person or an individual who was involved in the filing of patent, but after the filing of what you call patent infringement suit, you may be asked to search and see to what extent the patent is valid. And this search is actually again a search with regard to all the criteria which makes an invention patentable. Now, let us see some of the grounds. I am not going into details, and as you can just to reflect that what are the grounds on which revocation can be claimed, and it is actually a long section, it is a long provision. I will highlight some of the provision in order to show that how such becomes relevant. Number 1, for example, 64(1)(a) of the Patent Act says that the invention was claimed in a valid claim of earlier priority date contained in the complete specification of another patent. So, see, this is actually again a question of priority date, and priority date of an invention which is reading on the existing on the patent in respect of which revocation has been claimed. Then again, if you see that the patent was obtained wrongfully in contravention of the right of the petitioner. Then again the third point, if you look into it is basically saying that the patent is not falling within this patentable subject matter. So, it is something which is not which is to which section 3 is applicable. So, this can happen. Then again there is actually another ground, the patent is not new. So, it is publicly known or publicly used or published before, again this is actually a prior art search. So, what we can understand from here, that patent search is not something which is required when you are filing a patent or when you are basically responding to an office action, or when somebody says that actually you challenge it before opposition, but patent search is something which can be done at any stage during the life of the patent to ensure that the patent is invalid, or to actually support that the patent is completely valid. In this regard, actually I think it is also important to look into some of the issues, like what are the things which can happen, because since we are discussing about patent infringement suit, and then in the coming class I will be discussing about the issues that what is direct for primary patent infringement or literal patent infringement, and what is non-literal patent infringement, and in that context I will bring in the issue of doctrine of equivalence, and in that context also patent search becomes very important. So, here since we are discussing about enforcement of patent right to patent infringement suit, and since this is also a course for the lawyers, I will spend few minutes on what are the reliefs which are available in a patent infringement suit. As we know that the first set of relief comes when the suit is filed, and as we know that it takes actually a 1 to 2 years time, or in certain cases 3 years time to completely decide a case. So, during this period from the date of filing of the suit to the date of disposal of the suit, the innumerable orders are passed, and some of the orders are very important orders which basically protects the patent holder. And the general provision, as we know, that order 39 rule 1 and 2, which talks about temporary injunction, and the way temporary injunction is applicable in any suit. Say for example, in case of a property related suit, in case of actually other suit, Similarly, it is also applicable in case of patent infringement suit, whereby the defendant would be temporarily restrained from manufacturing the product and the process that is infringing the patent. In addition to that, there are certain special remedies which are applicable in respect of intellectual property, and these remedies are like Marieva injunction. Then it is we know about Anton Piller order, and we also know about a John Doe order. So, what are those? Let us spend few minutes on that. See, first of all, this Marieva injunction is something which has been created by the English court. As you can see in this screen, it has been created by the English court in the case of Marieva Compania versus International Bulk Carriers. So, this is actually the decision comes from the famous English judge Lord Denning. Now, what is this order? This order is basically passed when there is a danger that the defendant is actually would be moving the assets from the jurisdiction of the court. Suppose we know that at the end of the process, if the plaintiff, that means the patent holder, wins the case, the defendant would be required to pay damages, and then if he can actually ensure that no property is available within the jurisdiction of the court, the decree which has been passed cannot be enforced and the decree becomes infractuous. Because as we know that after the passing of the decree holder has to approach the same court where the trial has begun, and he has to initiate a proceeding under order 21 of Civil Procedure Code. Now, what is the order? This is actually an order whereby what will happen, that there is a likelihood that the defendant would remove all assets from the jurisdiction of the court, so as to ensure that the decree passed against him is frustrated. In such a situation, in Marieva injunction, what happens? The court passes a decree, thereby the court actually freezes the asset of the defendant. It can be actually the court can pass an order asking the bank to freeze the bank account. It can actually can pass an order, thereby the defendant can be restrained from what you call selling all the immovable properties which he has in the jurisdiction. Now, this is actually this is highly detrimental to the interest of the defendant, if we look into from the perspective of equity, and therefore, this order is sparingly used by the court. And normally, this order is shot on day 1 when the plaint is filed, and it is actually passed ex parte without hearing the defendant, and normally this is based on a petition which is supported by an affidavit. Therefore, when the court is absolutely sure that the defendant is going to run away from the jurisdiction of the court, defendant is going to remove all assets, movable, immovable, cash from the jurisdiction of the court, this order is being passed. And remember, this order, the validity of the order begins from the date of the order, and this order remains till the disposal of the suit. Next, actually, in our CPC also we have a provision, although which is not directly talking about Marieva injunction, the remedy which has been propounded by the English court, but this is order 38 rule 5 of Civil Procedure Code, which says that I will read out the relevant portion. It contemplates that if at any stage of the suit the court is satisfied that the defendant with the intent to obstruct or delay the execution of the decree that may be passed against him is about to dispose of or remove from the court's jurisdiction the whole or any part of the property, the court may direct the defendant to furnish security in a specified sum. So, here what is happening? Here, instead of freezing the asset, the court is asking the defendant to produce bank guarantee or and to give some kind of financial guarantee. But as we know that section 151 of the Civil Procedure Code gives under that provision the courts, including the trial court, they have inherent power, and there is no way we can actually prevent a court from actually passing an order under 151 of Civil Procedure Code restraining the bank from allowing the defendant to use the account. So, a free account freezing order can also be passed under section 151 of Civil Procedure Code. Now, the another type of remedy, the most difficult is actually what will happen the moment the defendant, the infringer comes to know that a suit has been filed against the infringer, he would actually destroy all evidence, the say for example, duplicating machines and other thing, to ensure that the allegation of infringement has not been the plaintiff fails to prove the allegation of infringement. Keeping in mind that kind of destruction of evidence which can be used for the purpose of implicating the defendant, actually what he does he basically destroys the evidence. Now, before he comes to know that a suit has been filed, if an inspection team goes to the facility where the infringing activities are carried on, and if that team collects the evidences, in that case that evidence can be used for the purpose of implicating the defendant. See, if the defendant comes to know that infringement suit has been filed, he will destroy evidence, but the day one when the suit is filed, if the court is so satisfied, if the court passes an order, and normally the court appoints a court officer. A court officer may be an advocate, an advocate who is an independent practitioner, and the court can ask that advocate to go and inspect the facility of the defendant and collect all material evidences there. And so, this is known as what you call Anton Pillar order, and we have seen very often a Marieva injunction and Anton Pillar order is issued simultaneously. Similarly, in our law also we have a provision, that is order 39 rule 7 of the Civil Procedure Code, and which is almost similar to what the English understanding of Anton Pillar order says. What is this understanding? It says that for the purpose of the here the most important provision is this, for any of the purposes aforesaid, any person to enter upon or into any land or building in the possession of the other party to the suit. For what is the provision is actually for the purpose of collecting obtaining full information or evidence, a person can enter the premises of any person, and that any person includes the defendant. So, it is also possible for a court to pass an order under order 39 rule 7, which is very similar to what you call the Anton Pillar order. Now, here another provision is very important, that is what you call John Doe. Here there are situations where the patent holder does not know who is infringing. He is aware that somebody is infringing, but he is not able to find out the entity of that person. In that case also it can be the suit can be filed against unknown defendant, and this filing of a suit against unknown defendant is called what you call John Doe order. And then as we see that order 7 rule 1, which talks about plaintiff, it says that that Civil Procedure Code it provides that it should contain the name, description and place of residence of the defendant. Then the most important part, so far as ascertained can be ascertained. So, if after all reasonable effort, if the plaintiff is unable to ascertain who is the defendant, still he can file a suit, and which is allowed in Indian court also. It is known as John Doe order. And in one case the Indian court has said that you will be calling it Ashok Kumar order. Now, here one point is very important. The plaintiff is required to identify the missing party with sufficient specificity such that the court can determine that the defendant is a real person or entity who could be sued in a court. So, this is what the American court has said in one case, and it is, I think it is, this principle equally applies in India. Now, here there is again such comes into play when it comes to the evidence, the burden of proof is concerned. See, we know that we have understood by now that there are two kinds of patents which are issued in India. One is a product patent and another is a process patent. Now, there is certain special rule with regard to the burden of proof in case of a process patent. Now, what is this burden of proof? The burden of proof is actually when the plaintiff files a suit for infringement of process patent. It is normally what is the rule is this, that in any suit the rule is this, that he who alleges a fact must prove it. So, if the plaintiff is alleging that the defendant has violated his right, the normal general rule is this, it is for the plaintiff to establish, it is for the plaintiff to prove that the defendant has violated his right. But when it comes to process patent, it is reverse. So, what it says that section 104 capital A subclause 1 of the Patent Act tells us that in a suit for infringement of patent, where the subject matter of patent is a process for obtaining a product, the court may direct the defendant to prove that the process used by him to obtain the product identical to the product of the patented process is different from the patented process. So, let us come to let us try to understand this with the help of an example. Suppose a task has been implemented by two different known processes and those processes are in public domain. A person comes out with an improvement thereupon which addresses a technical problem, and let us say that the new process actually addressed a long felt need. It is actually, it has made sufficient technical contribution and it has solved an existing problem. The person who has come out with the new process, he can apply for a patent and he would be enjoying a patent right over that process. However, what is the product which is coming from that process would not be protected. So, suppose in that case a patented process is there, he got a process patent. In that case, that in order to prove that the process patent has been violated, the plaintiff is just required to file the suit, and if the plaintiff is satisfied, if the plaintiff is able to satisfy the court will place the burden on the defendant to prove that he is not using that process for the purpose of coming out with the product. Now, why it is like this? See, to be very precise, it is not possible for the plaintiff to know whether the defendant is following the known process, that is process number 1 or process number 2. He is thinking that the defendant is using the patented process over which he has section 48 rights, and therefore, what he does, it is up to the defendant to show that he is not using the patented process, rather than he is using the known process, which is process 1 or process 2, and therefore, the burden of proof is on the defendant. Now, with this, let us go forward. In a patent infringement suit, the remedies which are, what are the permanent remedies? The permanent remedies are injunction and damages or accounts of profit. So, injunction is the first remedy, thereby the defendant is prevented from further infringing the product, and then whatever, since he has violated the rights of the patent holder, he is required to pay damage. if he is not required to pay damage, the court can ask him that the profit which he has made so far, but through the infringement, that profit must be handed over to the plaintiff. Now, in this regard, let us look into some other issues. Is it possible for the defendant to say that I am an innocent party, I was not aware that I am infringing patent right? The answer is no. Innocent infringement defense is no defense in an intellectual property litigation. It is no defense in a patent infringement litigation. Why? Because patent infringement is a strict liability tort. In this regard, I just want to mention what is a strict liability tort. Strict liability tort is a tort where whether the defendant is at fault or whether he has no fault, the court will not take into consideration. For example, this is actually also known as the Rylands versus Fletcher tort. If I am dealing with something which is by nature hazardous, in that case, no matter whether I have taken proper care or not, if that hazardous substance creates actually injury to someone else, irrespective of my care, I will be liable, and this is called strict liability tort. We have seen that it is also there in case of Motor Vehicles Act, which is actually a statutory damage is there, no matter whether the person who has who is involved in the accident, whether he has taken reasonable precaution or even though he is not negligent, still he is required to pay statutory damage. Similarly, in case of patent also, the defendant, he cannot say that I am innocent and therefore, do not impose any liability on me. So, from this, however, there is a provision, and this provision is very interesting, which is there in section 111. It says that if 111 subsection 1 of the Patent Act, which says that if in a suit for infringement of patent, in a suit for infringement of patent, damages or account for profit shall not be granted against the defendant who proves that at the date of the infringement he was not aware and had no reasonable ground for believing that the patent existed. So, in a patent infringement suit, if the defendant really comes forward and proves that he is innocent, in that case he cannot be absolved from the liability. The court will pass an order of injunction restraining him from further infringing product. However, if the court is satisfied that he is really an innocent infringer, in that case the court will not impose any damage or will not ask him to show accounts of the profits. Now, here actually the first we need to know what are the defenses in a patent infringement suit, and with this I will conclude. See, as we have seen, the first line of defense is claiming revocation under 64, and in addition to that there are certain exemptions from what we call the liability from patent infringement. And the most important provision, which is also known as the India's Bollard exemption, section 107 capital A of the Patent Act. What it says? That it says that for the purpose of this act, any act of making, constructing, using, selling or importing a patented invention solely for uses reasonably related to the development and submission of information required under any law for the time being in force in India, or importation of patented products by any person from a person who is duly authorized under the law to produce or sell or distribute the product shall not be considered as a infringement of patent rights. We know that India is the largest market, is the largest producer of generic drugs in India, in the world. Now, suppose as you know that the government of India also wants the doctors to prescribe generic drugs. Suppose if so long the patent is valid so long the patent is effective, no one can come out with a generic product. However, it does not stop a generic manufacturer from doing further research on that product, so that once the patent expires, once the patent is once the patented invention has fallen in public domain, that generic manufacturer can produce the product and he can produce it at a lower cost, he can come out with a better version. All this is possible. So, Patent Act in fact allows that. So, here also, in order to claim this kind of Bowler exception, again the generic companies must be advised about the nature, scope and the 4 squares of the patent right. So, here we need to understand that look at patent. Patent is actually, patent claims are nothing but the boundaries of the patent owner's right. In the real property context, what we see that when someone is buying a land, we normally end that sale deed with a schedule which says that on the eastern side such and such land, on the western side this is the land, on the southern side this is the land. So, we give a boundary. The patent claims in a patent specification exactly performs the role of laying down the fence of the patentee's right. And laying down the fence of the patentee's right is the most important thing. But however, it is understood that anyone who is working beyond that fence, anyone who is working around, he should be allowed, and that is the policy of the patent law. Keeping in mind this, therefore, section 107A of the Patent Act has created an exception. So, there are databases, patent databases, where you will find that it is possible to do technology mapping, patent mapping, to understand the scope of the patent right of others, so that a person can find out the zone where he can work for a further development or to come out with a new invention. So, patent search is important to create a map, and it is, as we have seen, it is important at every stage of the patent life of the patent. Thank you so much, and we will continue with the remaining part in the coming class.